Good morning, everyone. Thank you for participating in today's webinar about copyright licensing, particularly licensing your copyrighted materials to other people and other organizations. And as we move on to the second slide, this presentation is going to be divided into two parts, and we'll have an opportunity for questions after each part, but feel free to submit your questions during the webinar, and we'll take them during those two breaks. The first part is going to talk about copyrights generally, explain what they are, explain what what rights they actually convey. And the second part, we will talk about licensing. So this presentation is delivered as part of the Pro Bono Partnership of Atlanta. Some of you on the webinar are already clients of the organization. If not, please reach out to the organization if you are part of a nonprofit organization. You can certainly find information on their website, which is listed on this slide. In general, you need to be a 501c3 nonprofit organization and need to be focused in the metro Atlanta area. And if you email the contact information or go to the website, they can help you with additional screening criteria. And of course, since this is a legal presentation, we have to have disclaimers. And this is intended to be just general legal advice. And if you have a particular question specific to your organization, please seek out an attorney for help, particularly take advantage of the Pro Bono Partnership of Atlanta. And fittingly, in this copyright presentation, this is copyrightable material. So as we move into our presentation, background on me, my name is John Bush. I'm an attorney at the law firm Bryan Cave. We're an international law firm with 1,000 attorneys. My practice focuses on intellectual property and technology issues, particularly those involving patents and copyrights. And of course, copyrights are our focus today. We see that copyright symbol everywhere. It's almost ubiquitous. And you see on the slide just some random examples of the copyright symbol. You see it in the front cover of a book. You see it on this Taylor Swift CD, that Circle C. And even if you don't see the Circle C, you still see the statement that a copyright is owned, such as in this Dow Jones and Company assertion of rights in a Wall Street Journal article. So we see these symbols everywhere. The next question is, well, what do they really mean? Well, a copyright is pretty straightforward. It is a legal right created by the law of a particular country, and for our purposes, we're focused on the United States. It protects the creative expression of an author. Although we see these copyright notices everywhere, those notices are not what convey the right. The right is inherent in the document itself and protecting the expression. So with or without the notice, copyright protects the creative expression of the author from unauthorized copying. So the federal statute sets forth examples of copyrightable materials. Obvious example, literary works, books, musical works like that CD that we had the picture of earlier, dramatic works like plays, pantomimes, choreographic works, so basically dance routines and other things like that that are expressions, pictorial, graphic, and sculptural works, so virtually everything in the High Museum would qualify as subject to copyright protection, motion pictures, audiovisual works, sound recordings, and architectural works. And with the right legal argument, additional forms of expression are protectable under copyright law. Now, this next slide shows random examples of copyrights, and as we go across the slide, let's start with the New York Times front page. That very layout is an expression. That layout is protectable. The articles within it, to the extent that they are expressions by the journalist in presenting facts, those are protectable expressions. Importantly, and we'll get into this later, the facts that they're presenting are not copyrightable, but their way of presenting the facts would be. So as we move across, we see that photograph, which some of you will recognize comes from the Atlanta Botanical Garden. The photographer of that photograph picked a particular point with particular lighting and a particular backdrop to take that photo. But somebody could independently come in later and take an identical photo. As long as it's independent of the first photographer, you have two independent copyrights that don't conflict with each other. Because copyright protects expression, they don't exclude somebody else from independently arriving at the same expression. We also see a little bit of that below when we look at the photo at the front of the Fox Theater. Certainly the photo is protectable, much like the one from the Atlanta Botanical Garden. But also the substance relayed in the photo is protectable. So we see a play, we see the National presented. Certainly the script for it would be protectable under copyright law. The sets, the stage costumes would be protectable under copyright law. Uh, there's simply multiple aspects that would reflect expression that somebody has creatively arrived at that nobody else could simply steal and use for their own purposes without authorization from the author. And then lastly, we get to an interesting point, which in that bottom right-hand corner, when we see the Microsoft Word logo, because there's sometimes confusion between trademark and copyright law. So we see this right now. Somebody has come up with a creative expression for the Microsoft Word logo, and that is protectable under copyright law to the extent it is an expression. At the same time, that graphic is also used to identify as a trademark Microsoft's word processing program. So while two people can independently come up with the same creative expression and they will each hold a copyright and be able to coexist with each other, trademark is not intended to protect expression. It's intended to protect branding and identification at the source of goods and services. So because Microsoft has trademarked this for use in identifying its service of Microsoft Word, it cannot be used by somebody else. This is just a sliver of the distinction between the two, and we're just focusing on copyright and the expression that comes with it, but you may sometimes hear in discussion trademark used alongside the term copyright. And we mentioned earlier that copyright only protects expression, not facts. So there's no protection in the fact that the Braves have an 18-20 one-loss record. There's no protection in the names of a telephone book. You may have some protection about how the Atlanta Journal-Constitution presents facts and its news stories about the Atlanta Braves record, but you cannot copyright the underlying facts, much as you cannot copyright the names and telephone numbers in a telephone directory. So we've talked a lot about what copyright is, but definitionally, what are the rights conveyed in copyright? Well, first and foremost, you have the rights to distribute and reproduce the work. They're definitional in the item. The author controls how a work can be, when a work can be copied and when it can be distributed. Now, in practical effect, an author is normally collecting royalties at that first point of sale, and the author cannot control subsequent sales. But at least on that first point, the author has that ultimate control and simply chooses to relinquish that control by way of selling his or her rights to someone else. Then we get to the display and perform rights, which overlap, and that's akin to an artist presenting artwork and choosing the form in which something is presented. To a certain extent, movies, how a movie can be displayed in public. And then we get to creating derivative works, and this is of particular interest to your organizations. There is an idea that perhaps you write it. Well, certainly, for example, with a book, you can have a book. You can create a sequel to the book. The sequel, in all likelihood, is a derivative work of the original one. For your organizations, you may have a version 1.0 of a document, and you subsequently want to create a version 2.0 of a document, or somebody else would like to create a version 2.0. Your copyrights in version 1.0, to the extent that they are incorporated into version 2.0, you still own rights in that version 2.0 under the principle of having derivative rights in a work. And lastly, we have moral rights, which are amorphous and probably outside of the scope of this discussion. They are the idea that the actual author of a work should be attributed as the author and that nobody should wrongly be inserted in that author's place. Now, we sometimes have authors under pseudonyms or ghostwriters. That's a different case, but it's the idea that if somebody actually creates a work, the author should be credited for it and nobody else should falsely claim credit. And there's a related concept under moral rights that copyrighted material should not be placed in a position by which it would be disparaged or otherwise damaged. It's a very amorphous area of law, but just raise it here because it is part of copyright. And of course, copyrights are quite serious in the marketplace. The damages can be quite devastating. when you have a registered work that is infringed. If the infringement is unintentional, your damages can range from $750 to $30,000 per instance of infringement. And if it is a willful act of infringement, you can have statutory damages up to $150,000 per instance. Even if there are certain statutory formalities that have to be followed for those particular damages, but even lost profits could be a realistic form of damages that somebody could be exposed to for copyright infringement. And that's something that both your own organization should be mindful of in how you use other people's works, and also it is a great sword to wield against people who may be infringing the work that you've invested time and effort into creating. So we provided a very general overview of copyrights, and if there are any questions, we can pause for those now. Okay, we will continue now. So as we move on to nonprofits' own copyrightable content, there are many things that organizations have invested time and effort into creating, from fundraising brochures, curriculum and training materials, the photographs you've taken at events, articles, the content on your website. Some of you, I'm told, have developed software. Each of these materials that you spend time and effort into creating is protectable under copyright law because they are expressions and you have put a lot of effort into creating them. It may be that somebody comes to you in the course of seeking out what's out there and says, well, this is a great fundraising brochure. We would like to take advantage of it for our organization because we have a similar goal. Maybe we're not competing with you. Maybe we're in a different part of the country, different part of Georgia. Maybe there's some study, something else that you come out with that would be useful for that other entity to reproduce. And again, they want to give you credit. And there may be some other organizational overlap that they want to take advantage of works you've already worked on. Given these copyrights, there may still be other uses that people have as well. So you have a choice. You can certainly allow them to use your copyrightable content, or you can tell them no. You have the right to do anything. But if you choose to let them use your materials, I would encourage you to consider certain options, and particularly have some simple formal agreement that recognizes this is your work. And that's simply so that you can protect yourself. You are recognizing that you have gone to the effort of creating this material, that there's no confusion down the line as to who created this material. And it also further recognizes the work your organization has done. So it can be a short, simple written agreement. It identifies the material to be licensed. It recognizes your ownership of the material. It is not necessary, but it would be highly encouraged that you would recognize that to the extent that a subsequent licensee of your materials modifies, tries to adapt them for a new purpose, that you would certainly have rights to that added content, and in an ideal circumstance, you would own that new content. Certainly, we have a client that we've done a lot of work for that creates wonderful pamphlets and materials that are distributed in the as part of training materials to its client companies, and those client companies are free to modify them and adapt them to their employees to whom the materials are ultimately delivered. But the client, as the original author of the documents, has contracted that it will always have a license to those materials and modifications to them, and that way it can continue improving its own materials. In the course of preparing your written agreement, you want to consider, well, how long will this engagement last? Is it just that you want to provide a short-term license because they have some limited purpose? More commonly, you may be providing a long-term license, a perpetual license, that's as long as you have copyrights, the licensee will have those copyrights as well. It's also important in that same context to consider whether the license will be exclusive or non-exclusive. And in the nonprofit context, I tend to think that you are looking at a non-exclusive license because you may come across somebody else who would like to use your materials for the same purpose, and you don't want to foreclose your ability to license those materials to that subsequent person who approaches you, and you don't want anything that would prevent your continued use of the materials. You probably want to consider making the right non-transferable. This just makes it cleaner from the standpoint of you giving the right to someone. They can't just immediately turn around and give that right to some other third party who you have no connection with. There is a potential to devalue the license, not in all circumstances, but that's why I would encourage you to consider a non-transferable license if you enter into such an agreement. And you need to consider whether the royalties are appropriate. For some organizations, you may be in a position to collect royalties based upon your copyrighted materials that somebody else is using. Now, as a nonprofit, you need to be aware that you are a 501c3 organization, and certain revenue-generating endeavors that are not directly tied to your mission may incur tax consequences, and I encourage you to reach out to the Pro Bono Partnership of Atlanta for advice in that situation. And of course, with all of these, with increasing importance and complexity, you should consider reaching out to an attorney. And that particularly holds true in the event you find yourself in a situation where you are entering into a software license where you are licensing software that your organization has developed to others. I would highly recommend you engage an attorney the first time that you go through this process. If you do not, here are some considerations for you in entering into a software license. Certainly everything that we've just expressed on the page before, but also source code. Is there any access to the source code, or are you solely providing access to the machine executable source code, the object code? Are you providing any indemnification or warranties with the software that you're licensing? Do you have any obligation to provide ongoing support? And who owns the modifications, which again goes back to derivative works. Of course, whether you enter into a formal written agreement or whether you simply continue to exist without knowing anybody's using your copyrights, it's probably healthy to periodically check to see whether anybody is using your intellectual property that you most value. Sometimes that's just entering a search into Google and seeing how your organization shows up, or seeing how certain key phrases in your documents may show up in time. This isn't something you have to do with all of your materials, but if you particularly value a set of materials, that would be an advisable step. Because if you do encounter unauthorized use, you may want to reach out to that unauthorized user. Depending upon the situation, you may ask that they take it down. You may ask for proper attribution that you and your organization are the true authors of the document. You could ask for a formal licensing agreement along the terms we've just discussed, and particularly if they are making money off of your materials, it would be entirely appropriate for you to seek royalties based upon that, if that's what your organization would like to do. Unfortunately, many times with infringement, and hopefully this doesn't happen to your organizations, but most times you only discover infringement by a fortuitous event. But to the extent that you do care about your intellectual property, it's something you can periodically monitor for. Now, we've discussed copyright registrations, and you can consider registering a copyright in your works. Now, importantly, everything you create is immediately protected by copyright law at that very moment of creation. You do not need to take the separate step of registration. Registration confers some benefits. It more readily identifies the work, such as when we go back to that simple licensing agreement and we talk about its benefits and its need to identify the copyrightable work. Sometimes it's much easier to identify a copyright registration rather than amorphously try to describe something that does not bear a copyright registration. So that's one consideration. And then the second one, which hopefully, again, your organization's ever encountered, is if you need to sue someone for copyright infringement, you must have a copyright registration. And in fact, to receive the statutory damages, you must have had the copyright registration very close to the time that you first published the work and made it available to the public. Otherwise, you won't collect the statutory damages, and you will be left solely to trying to collect your actual damages, lost profits, or some other injury by virtue of someone's unauthorized copying. So given that you have an inherent protection, when should you actually consider to copyright? and register a copyright in something? Well, it's $35 per work. Uh, what I tell a lot of clients is if you value the work highly, you should consider pursuing a copyright registration because it's only $35. It'll probably take 9 to 15 months to have the registration certificate come back to you. But it's a pretty small price to pay for the protection it provides. But coexisting with that, there is just no reason to go about and copyright every single document your organization produces simply to have that protection. As nonprofit organizations, you're prioritizing uh, the funds you have, and I would only suggest that I only encourage you to consider registering copyrighted work when it's something that your organization highly values or spent considerable resources working on. But again, that's a conversation you can certainly have by reaching out to the Pro Bono Partnership of Atlanta and speaking with an attorney. So that concludes the presentation. Thank you for the opportunity to deliver this. Are there any questions on the webinar? Okay. Speaking of copyrightable works, there's a movie being filmed in the lobby of this building right now. We don't know the name of the movie, though. That's an excellent question. And the question, if you did not hear, is if an organization has a trademark registration, does it also need a copyright registration? Correct me if I misstated that. Trademark protects branding. So if your organization has a brand, you have trademarked that brand to keep somebody from stealing the goodwill in that brand. In the nonprofit context, sometimes that trademark exists to protect a funding source so that nobody else comes in and tries to represent itself as the ABC organization and steal funding. One of the first cases I worked on was two cancer organizations fighting over in a trademark dispute over funding because one was using the other's trademark to receive funding. So trademarks come into play from a branding standpoint, and they protect you from source confusion, that somebody else confuses who the source of goods is when you're using that particular trademark. Copyright is something else entirely from what it intends to protect. It intends to protect the creative thought that goes into creating some protectable expression, whether it's a literary work, a document, or an audiovisual work. So you should, if an audiovisual work or some other expression needs to be protected, that needs a separate registration or a separate consideration about how you will protect it. Trademark is only to protect your source identifier. And I'll take a follow-up if I fail to answer that one adequately. Okay, we have several more questions. The next question is, if I had a workbook for a curriculum, would that be one copyright for $35? Yes, the compilation. Oh, sorry. Yes, I need to repeat. The question is, if you have a workbook, it has a set of materials, would that be a single copyright registration? And the short answer is yes. It would be the entire workbook could be submitted as a copyright for registration to the Copyright Office. It is a form that can be completed online. You pay your $35, and within a period of months to a year, you would receive a registration back. It can be a potentially nebulous area of copyright law over to what extent do you need to copyright the subparts, and you can certainly consider reaching out to an attorney to advise you over how many copyright applications you need to file. A rule of thumb is, well, what are you handing out? Is it just the workbook that you're handing out, or are you just handing out these little subparts of individual chapters, but not so much the overall workbook? It's really a case-by-case basis determining how to proceed, but as a general rule of thumb, if you have a complete workbook and it's treated as a workbook, it's safe to say that that is a complete document, a single work that can be submitted for copyright registration as part of an application. The next question is, could you give us some more examples of Uh, the three best examples. Oh, sorry. Yes, I keep failing to restate the question. Could I provide additional examples of nonprofits licensing their materials? The three common examples. I've learned that Pro Bono Partnership Atlanta has clients who prepare software and need to and are in situations where they've been asked to license it. Sometimes with that software, it's actually software that would have a third-party use. Sometimes it's something as simple as it's just an internal database, an internal sorting system, and there's another organization that would like to take advantage of that system and what would go into licensing that. So that's on the software side, which we sort of covered earlier. Additional consideration would again be there is some study. You'll see this with organizations that have put a lot of effort into researching some issue to raise awareness of it. And other organizations may not have spent that same amount of effort in researching an issue and trying to raise awareness of it by having this written material or presentation, and those other organizations want to take advantage of it. It could be as simple as just having that placed up on the website. It could be wanting to distribute it as part of a fundraising function. That's an additional example. And a very common example would probably be you photographed an event. You have some other graphic, for example, a graphic showing, well, here are poverty levels in Atlanta over the by decade. Uh, that reflects certainly some research work, but sometimes the real expression and the real appeal of something is how it visually presents it. And I think that would be a very strong example uh, of a very minor item, which nonetheless, if your organization prepares it, spent the intellectual resources thinking about what is the best way to present it, that somebody should come to you and say, we'd like to use it, may we have your permission? Of course, with something as simple as that, you may say, look, just give us credit, we don't need a written agreement. But if and that's up to your organization on how you want to proceed with that. Certainly, a lot of organizations may consider that that's not worthwhile to go through the trouble of written agreement. Others may say, no, we spend enough time on this. We just want to have a short, simple statement that we own it, but we give you permission to use it for this certain purpose. Well, thank you for letting me participate. And if you have any questions about this presentation or want to participate in future webinars with the Pro Bono Partnership of Atlanta, please go to the organization's website. That material